Yes.
My Lord, before I go on to look at the detail of the application of the principles that have been discussed this morning to the board, I should deal with the Shagang shipping case, which was drawn to our attention before lunch.
I can see it's slightly far removed from the public law circumstances which you're addressing, but
it's we would say plainly of assistance to our submission, in that what it says is that in re-H does not provide a rule which applies across the world of judicial decision making. Paragraph 97, to which my Lord drew our attention, is effectively an encapsulation of the submissions I made less elegantly and more slowly in the hour or so before lunch. The only other part of the judgment which I would draw the court's attention to is paragraph 99, which sets out the proposition that the requirement to discharge the legal burden of proof, which operates in a binary way, applies to facts in issue at a trial, but does not apply to facts which make a fact in issue more or less probable, which is further explained in the last few lines of the paragraph, on the basis that judges need to take account as best they can of uncertainties and degrees of probability and improbability in estimating what weight to give to evidence in reaching their conclusions on whether facts in issue have been proved. It would be a mistake to treat assessments of relevance and weight as operating in a binary all or nothing way. Assessments of weight in particular are at the heart, relevance and weight are at the heart of what the panels of the board have to do.
thank you.
Return then to the particular circumstances of the board, and the developments which led to this appeal really began with the judgment of the Divisional Court in Warboys, to the effect that allegations of wider offending, that is, matters which have not been adjudicated by a court or tribunal, may have to be considered when determining the issue of risk, even where the board is not determining whether they happened. And Warboys informed the board that evidence of wider offending can be, and in some cases would need to be, considered as part and parcel of a global assessment of risk. The Divisional Court handed down judgment in Warboys in March 2018, and the board promulgated this guidance in its original form in March 2019. And there are 3 first instance decisions which considered the proper approach after Warboys, and they are Delaney, Morris, and this case. And in order to attempt to assist with some more concrete examples of the way in which this guidance plays out, what I propose to do is to take the court to those 3 first instance decisions.
Thank you.
Delaney is, it starts at page 667. It's the first in time of the cases. It predates the guidance. The decision of the panel was taken in June 2018, and the judgment of Mr. Justice Andrew Baker is from March 2019, shortly before the guidance was issued. Can I start, please, on page 669 by taking the court to the panel's decision in order to give you an understanding of the facts in issue and the way in which the panel assessed them. At paragraph 6, 2 paragraphs from the panel's decision, 14 and 15, are reproduced. Can I ask the court to read those, please? At 670, the judge described that approach of the panel as being not to make any finding as to what had actually happened, but nonetheless to treat the fact that the allegation denied by Mr. Delaney had been made against him as in itself a matter from which it concluded there was real risk. And then there's a reference in the following paragraph to part of the decision, highlighted parts of which are that the offender manager, Ms. Berry, said, and the panel agrees, that the allegations which led to your recall had increased your risks, and then your reported conduct is, in that sense, offence paralleling. The conclusion of the judge is at paragraph 13 on page 671. The starkness of the decision letter in its express decision not to make any relevant finding, but to go no further than a conclusion that there may have been truth in the allegations, but then equally there may have been none, and its flawed logic that the allegations led to an increase in risks, means it is impossible to say whether, and the argument on this judicial review has not considered this in any detail, there was before the panel evidence it was entitled to treat as admissible, sufficient to enable it to make findings about Mr. Delaney's behaviour that might have justified the conclusions as to risk it reached. So this is a case where allegations have been made, and without inquiring into the basis for those allegations effectively any further, the panel has concluded that that is sufficient. And what the judge said needed to be done, it's the last few lines of paragraph 12, in such a case as the present, the panel must in reality either disregard the allegation as being, so far as it can see, no more than an allegation, or undertake an investigation and consideration of any evidence that may be presented to it of the conduct of the offender, enabling it to make at least some findings of fact as to what did happen, by reference to which, as a factual basis for any conclusions, it might then consider the question of risk. What's missing from the panel decision in Delaney is the evidential basis in reality for the finding of increased risk, and the judge's criticism is effectively that the panel didn't make any inquiry to see if there was evidence which would have assisted it in terms of whether the circumstances of the allegation led to an increase in risk. Some of the words of those paragraphs are reflected to some extent in the guidance. The need to make at least some findings of fact, and the fact that a mere allegation is unlikely of itself to be sufficient. Had the guidance been available, one can only speculate, but it may well be that it's unlikely that the panel would have taken the approach that it did. So Delaney really is a case of a panel having nothing before it other than a single allegation. There's another case in the bundle.
Sorry,
yes.
I'm just trying to understand that. I mean, looking at paragraph 6,
yes,
the board had the evidence of D.S. Fuller.
Yes.
And in paragraph 14 of the board's decision, it's recorded that he explained, despite having video evidence, presumably on the policemen's jackets when they were called to the scene, there wasn't enough evidence to be used in court.
Yes.
So they didn't proceed. And then they were able to agree with his assessment that there were reasonable grounds for believing that he'd been guilty of violent offending.
But what they don't do is explain on what basis they reached that conclusion, my lord. That seemed to me to be what the judge at first was critical of.
There was his evidence based on whatever he said.
Yes.
Clearly not very much is said in paragraph 14.
Yes.
But he reached a conclusion based on whatever he said that there were reasonable grounds for believing that there was guilt of violent offending.
Well, there must have been a bit of information, mustn't there? If you look at paragraph 3,
Yes.
they're not just there's been domestic violence. There were reasonably specific allegations: a fractured wrist, a perforated eardrum, and an unpleasant assault.
Yes.
And then if you go to 6, you'll see that the complaint had been made presumably in person to a policeman and therefore recorded on his camera. So whether you can extract that or not and treat it as hearsay evidence, I don't know. That may or may not be so, but there must have been something. It isn't a case of just, we've heard you've been unpleasant to your partner.
No, there was material that the panel could have relied on in its decision, it appears, although it's not at all clear what the extent of that is, but my Lord's right to identify that material. But from what we have in this judgment of the administrative court, those materials don't appear to have formed the basis of the panel's decision. If they had done, we might have had a different outcome.
Well, you've also got the fact that he, when whatever it was put to him, he said, "Well, I've had heated arguments with her, but I've never done any more than that." And the panel, at least, assessed. Provocative word. Said that his denial was unconvincing.
Yes. And those are matters which the panel would have been entitled to rely on under the guidance, and we say properly, to support a conclusion of risk sufficient to require his continued confinement. This is, in one sense, not a bad example of a case where there is some evidence which a panel can rely on without making a finding of fact as to whether or not an offence has been committed, because that may go to their overall assessment of risk. So, as my Lord says, there was evidence of injury.
Well, no, there may not have been evidence of injury. There was an assertion of injury.
Yes. So had the matter been investigated further, it may or may not have been possible to obtain evidence. But that wasn't done because the panel reached the conclusion that the allegation of itself was sufficient. And it was of that the judge was critical.
I mean, that was the focus, wasn't it? If you look at the argument, paragraph 10, which is an allegation in itself can't found any particular degree of risk. And he accepts that and cites 3 cases which all say that, I think.
Yes.
One way or another.
And yes, I'll take you to one of them in a moment. That's right.
So simply the allegation in itself doesn't take matters.
Yes. And that's what leads in part, via Morris, which we'll come to in a moment, to that part of the guidance which says that a mere allegation is not sufficient. And I'll address the court on that in due course.
I see the Parole Board wasn't represented. Is that usual?
It's common in an ordinary circumstance where there's a judicial review of a decision not to release, because the board acts as a court, in effect, it takes the view that it's not... costs are a consequence of its non-appearance, as Court of Appeal and this court held in Gourlay last year or the year before. But also the board takes a view that it's not for a court to explain its reasons at a challenge. The reasons ought to speak for themselves on the face of the decision. Yes. So it's legally appropriate for it to take that approach. So the decision on this case, my Lord's right, is rather narrowly focused on the fact that an allegation of itself isn't really much use to a panel.
Well, first of all, do you want us to say that that's a principle which ought to be endorsed? In other words, do you want us to say that an allegation, the making of an allegation by itself, is not material the board can take into account?
I've taken instructions on that over lunch, in particular in light of my Lord's questions about where one has multiple allegations.
Yeah.
And it's right to say the guidance is worded as it is because the board conscientiously intended to issue guidance which was consistent with the judgments of the High Court which bound it, including Delaney and Morris. Delaney says an allegation of itself is essentially worthless. Morris says a mere allegation is insufficient, and the guidance could be clearer about that. Divisional Court said that in terms. What we would submit, first of all, is that it would be helpful to have guidance from this court. And the approach that we suggest is the right one, is that this is not, in essence, an issue of principle. It is an issue of assessment for the panel, and it may well be that it will almost, if I can put it this way, the board at the moment can't envisage circumstances in which a single allegation with no other evidence to support it could properly be given weight by a panel.
Well, was this that case or not? In your submission?
It shouldn't have been, because there were other materials that the panel should have taken into account.
Right.
And the fact of the allegation would have been one matter among many to be assessed by the panel and accorded such weight as it saw fit. An allegation where there is evidence to support the proposition that the allegation is true, so a corroborated allegation.
Oh, but that's independent evidence.
Yeah.
What about the much more likely case where you've got a complainant who makes a complaint saying of the prisoner, he's done this. The complainant subsequently refuses to cooperate. Lots of them do, some for good reasons, some for bad.
Yes.
But you've got the fact that she usually has said it.
Yes.
Now then, stop there. What's that? Is that what you've described as a bare allegation that the board must ignore, or is it something that it can take into account?
On its present guidance and on the guidance of the court.
I don't want to know what the guidance says, Mr. Collins. I can read that. What I want to know is what you want us to say. I know what Mr. Justice Baker said. What would help us to know is whether you want us to endorse it.
My Lord, the approach that we ask you to take is to leave this at the discretion of the panel.
So they can say that the mere allegation is enough.
It's part of the assessment process, my Lord.
So
It is.
yes, the assessment can it? I don't know whether this happened or not, and I can't make a decision, even on the balance of probabilities, but it might have done, and therefore I shall take it into account.
We do not, at present, envisage circumstances where that would properly be decided.
Well, I thought
but it's not a matter of principle in my submission. It's a matter of weight and assessment. The guidance we would suggest is of some assistance to panels, because it's important for them to understand that a mere allegation of itself is, in any of the circumstances that the board envisages, insufficient. But my Lord will detect I'm reluctant to concede, never say never, as it were, because of the infinite variety of circumstances which arise.
I'm still struggling with the concept of a mere allegation. I mean, what is a mere allegation? If you have a statement by a lady a written statement. Let us say, as Lord Hughes says, that the complainant chooses not to cooperate beyond the initial statement. But you have a statement by a lady to the effect that events happen. That is evidence, is it not?
It is.
Yes.
Which is why I say that it is not a matter of principle that the board cannot take into account what is treated as a mere allegation.
Circumstances, an allegation, if you allow hearsay, not evidence.
It is evidence, and the board, of course, is entitled to take all information into account.
Yes.
The guidance is no more than guidance. It is there to suggest that it is. I would prefer the formulation highly unlikely rather than impossible that an uncorroborated allegation will be sufficient for the board to rely on. The reality is that there will usually be something for the board to look at, and it's a feature of all of these cases, in fact, that there is evidence. There's evidence in Delaney and Morris, and in this case, which is why the Court of Appeal dismissed the appeal.
Why? I come from a jurisdiction where in criminal courts you need corroboration. You don't in the law of England in most cases, I think. Am I not right? Why do you need corroboration? What?
You don't as a matter of principle.
No.
As guidance for panels, the board is right to indicate that an uncorroborated single allegation is unlikely to bear weight. And the reason I keep repeating is that it's not a matter of principle, is that it is, in my submission, as a matter of law, simply a question for the panel to decide what weight they ascribe to it.
Wasn't Brooks precisely a case of an allegation made against the prisoner? It starts at 575. It's Lord Justice Kennedy's case.
Yes.
And what its authority for, generally at least, is that that the board can act on hearsay.
Yes.
The hearsay in question was a statement of complaint by a woman that she'd been, was it assaulted or?
Yes. So I'm looking at 583.
Thank you. Was there more? Perhaps there was. But she refused to come, didn't she? That was the point.
Yes.
And people sometimes have quite good reasons for not wanting to stand up in public and add to their complaints.
Yes, quite.
Sometimes very bad reasons, but there can be both. So what?
There was something more in Brooks, may not quite answer the point that my lord makes, but I noted paragraph 22. There's also a breakdown in trust as a result of a failure to disclose the true state of the relationship to the probation officer.
Didn't tell him about the new relationship. Yes, okay. But basically, what happened in Brooks was, as Lord Justice Kennedy's judgment makes clear, is that the panel found as a fact that what the complainant said had happened.
Yes.
On the basis of her written statement.
Yes.
There was also evidence, paragraph 19, from two individuals as to what the complainant had said to them, I think.
Yes. And there was some criticism of the court having taken their view of the credibility of that account into account. We now head into the territory of rationality, because there will be an opportunity, of course, for the prisoner to say, on the basis of this allegation alone, no panel with a proper appreciation of its responsibilities could reasonably have concluded that there was a risk. That is the way in which the law supervises the panel, not on the basis of a blanket rule about mere allegations, but on the basis of rationality. And the guidance, not intentionally so, but the guidance, I would suggest, really reflects the need for panels to act rationally. And Brooks may have been a case where, notwithstanding that there was no more than a hearsay allegation not backed up by any of the material matters, that the panel was entitled to conclude. Those cases, on the board's view, are likely to be rare, but likely because there's usually something.
Well, let me ask the question slightly differently. One of the things that worried the Court of Appeal was that the guidance might lead the board to work on the no smoke without fire principle. Being a complaint, may well be something in it. It's worrying enough to keep him inside. Now, are they entitled to do that or not?
I don't recognise the term no smoke without fire as applicable to the analysis that we looked at. If no smoke without fire simply means the mere fact of an allegation must mean that it's true, then that wouldn't be appropriate.
No.
What has to take place is a conscientious evaluation of what material is available. An allegation may be relevant. Panel will have to determine what the weight is. So it depends how much smoke there is and in what circumstances the smoke is observed.
I see.
Certainly, I don't want to divert you. I'd certainly be grateful for your assistance on the other cases that you were going to come to, which led to the guidance at some point.
Yes.
Yeah. Fair enough.
Yes, well,
because these illustrations, I, for my part, I'm certainly finding very helpful.
yes, well, I'm grateful. The next case that I was going to take, slightly out of turn, but because it's another mere allegation case, it's called Broadbent. It's a case which the first respondents have relied on, and it's just have a moment.
1028.
1028, very grateful. This is a case about a prisoner who, while released on licence, was arrested as he parked a van which didn't belong to him, and 40 kilograms of cannabis was found in it. And he essentially denied any knowledge of the cannabis. And Mr. Justice Stanley Burnton, on page 1033, identifies the issue in that case at paragraph 25. The major issue argued before me is whether the Parole Board was entitled to proceed on the basis of the charge and pending prosecution alone, without regard to any of the evidence upon which the charge and prosecution are based, or other considerations. And he held at paragraph 26, the fact of a charge and pending prosecution alone cannot, without more, justify a conclusion that there is a risk of reoffending. It's another example of a case where a panel might well have had available to it evidence which would have made its decision much more straightforward, but it relied instead on the prosecution itself. At paragraph 27, his lordship said that's not required to say the Parole Board is required in every case to consider all the evidence on which a prosecution is based, or indeed any of it, or that it must necessarily make a finding as to whether the prisoner did or did not commit the offence charged. There will be cases where the undisputed facts are sufficient for it to conclude there is a risk of reoffending. In the present case, there were before the board facts in addition to the charge and prosecution alone. Undisputed, the claimant was driving the van. A large quantity of cannabis was hidden in it. The board could consider whether someone dealing with that quantity of drugs would entrust its custody to someone who was ignorant of his existence and who might surrender it to the police, entitled to have regard to the claimant's past association with drug dealers. So it's a case where a panel has a basic starting point of an allegation, a prosecution. That of itself may not be sufficient, but there are all these other facts which the panel could have taken into account but didn't, and if it had done, there would have been, subject to questions of rationality, a fair basis to find risk.
So the fact of the charge and prosecution isn't irrelevant. But Sir Stanley Burton is saying that if there is more, as there was in this case,
yes,
then that's sufficient.
And if there's a prosecution, inevitably there must be something upon which the prosecution was based. And the prisoner would have an opportunity to say that what it was based on was insubstantial or insufficient for the board to place any weight on it. But in the case of a prosecution, somebody would have taken a decision to prosecute, and that would have been based on some sort of evidence.
But yes, I mean, it throws up another example of the kind of thing which I should have thought might well happen. Some of these cases are about events that occurred before the original sentence of imprisonment was passed. War Boys is a classic example. Yes. But sometimes it's like Broadbent. It's something that is alleged to have happened afterwards.
Yes. On
licence, usually.
Yes.
And sometimes the police are still investigating, or the CPS are still trying to decide whether or not they can put together a case of prosecution.
Yes.
What's the board supposed to do in that kind of situation? Actually, Justice Stanley Burnton's solution was simply to say, well, you defer it until after the prosecution's taken place, which may sometimes be a pragmatic solution. But supposing that's not available for some reason or other, what do you do? Is it fair to the defendant to try him before the panel for an offence for which he may yet be prosecuted?
I hope it doesn't sound like a pusillanimous answer. It will depend on the circumstances of the individual case, my lord. It's covered in the guidance. Paragraph 16 of the guidance addresses that very problem.
That's what it's about, is it?
Yeah, page 433. Panels should be very careful about making findings of fact in relation to allegations that are being investigated and may result in further enforcement action such as prosecution. Prisoners and their representatives may claim it's unfair that a finding of fact is made to a lower standard of proof where the procedural safeguards of a criminal trial do not apply. Panels should be clear on what they're making findings of fact about and why. So it will inevitably be a tricky situation, but that's a question of fairness. And that may well be a matter of procedural fairness, because a prisoner may well say, I cannot give you an account at this stage without prejudicing my position in proceedings elsewhere. And that may put the prisoner in a difficult position, because if they're not able to deal with it there and then, if it's a release case, then they remain in custody in the meantime.
Well, they may or may not do. That would be a matter for the board on your submission.
Yes, my lord posited the possibility of postponing the hearing, an oral hearing, before making a determination. So
I see.
Yes, that might at least conceivably result in the prisoner remaining confined. Let me turn to Morris at 675, which was the divisional court case in which Mrs. Justice McGowan and Lord Justice Irwin took essentially the approach that the board urges upon this court in this appeal. I don't rely on it for the reasoning, because I've already addressed the court on the in relation to the guidance as a whole. This court will form its own view and plainly isn't bound by the views of the divisional court, but we commend the reasoning of the divisional court to this court. But it's another example of a parole board decision which may be of some assistance in understanding how these issues play out in reality. The factual history starts on page 676. The terms of the circumstance of the index offence are set out at paragraph 3 in italics. I don't propose to read all of that out. And then on the following page, at paragraph 5, we see that the prisoner was released on licence. The licence was revoked following an incident on the 1st of March 2014. And there's a description of abusive and physically aggressive behaviour in circumstances where the victim didn't want to proceed with the case. but it was noted that the prisoner was in breach of his licence conditions for having failed to inform his offender manager of the developing relationship. The board's decision is on page 678 at paragraph 11. It refused to direct release, and the reasons are set out in the italics at paragraph 11, referring to an arrest in 2014, a harassment warning from 2017, and the difficulties in being open and honest with those tasked with managing you. Consider that the risk of serious harm remained high. And there are features of this case which findings are made about. Paragraph 12, they concluded you gave an inconsistent account of your relationship. Lack of honesty and poor insight at the top of page 679. But there is a reference at paragraph 14, allegations of assault and harassment. If we turn then to the way in which the court approached this case, and we jump ahead, please, to paragraph 56 on page 690, where the court, having taken Delaney into account, was satisfied there was sufficient evidential material to the board to have made at least some findings of fact. So the fact of Mr. Morris's arrest, his admission that things became verbally heated, knowledge of the existence of the ex-partner's retracted statement and relevant police reports, and a prevention of harassment letter. And then at 57, the factual basis was not particularly strong. There's no doubt the board would have been in a better position to assess the truth of the allegations had it obtained the reports and statements in advance of the oral hearing. However, these are matters which go to the weight the board was entitled to place on the allegations. So long as there was a sufficient factual basis, however limited, on which to take the allegations into account, the board was not acting unfairly. So it's another case where some of the allegations were not supported any further than the making of the statement in the first place. But there was evidence surrounding them, and the question of weight, how to assess all of those bits and pieces of evidence, was a matter for the panel. This case is where the expression mere allegations comes from, so far as I can work it out. It's paragraph 63 on page 691. Second line, the board is entitled to consider allegations where it's not in a position to make a full finding of fact. Nor do I accept the guidance on allegations encourages the board to adopt a no smoke without fire approach to allegations. As I've also explained above, it is unfair and therefore impermissible for the board to give weight to mere allegations which do not have any factual basis whatsoever. The guidance could make this clearer, and the guidance was adapted in order to give effect to that dictum. And I hope the court has my submission as to that, which is that the proper answer to this is not that there is a blanket rule, but that this must be a matter of weight for the panel.
As I've said, I still struggle with the idea of an allegation that has no factual basis.
Well, perhaps I can think about it in this way. Lord Brown-Wilkinson's example of the 5 sightings of aircraft which might be enemy bombers. On one analysis, those are 5 uncorroborated allegations, save of course for the fact that there are 5 of them, 5 independent sightings, and that pattern itself is another fact which might be taken into account. I reflected on whether I could give this court an example of a case where there aren't any facts other than allegations. None of the authorities provide us with that. And the closest that I have to offer the court is a prisoner sentenced to a Terrorism Act offence, where there are 5 reports of his having been in a group of people shouting terrorist slogans. And on each occasion, it isn't possible to identify that he was the person shouting the slogan. Another example would be in a domestic violence context, 5 separate allegations of domestic violence. In each of those examples, the number of allegations of itself, and we gave some thought to this in response to questions my Lord asked this morning, that the pattern is itself a fact, and that then is a matter of assessment of weight for the panel. The other example, and the example that we gave in our case, is War Boys itself, where the divisional court noted references in the parole dossier to the possibility of there being over 80 victims, by contrast with there having been over 12 convictions, and the divisional court noting, perhaps dryly, that if Mr. Warboys was to be believed, the CPS happened to have chosen the only 12 which were true to have prosecuted. And they held that further evidence or material could have been used as a means of probing and testing the honesty and veracity of the prisoner's account.
That was the point in War Boys, wasn't it? It wasn't so much whether he'd done it or not, it was that he'd been telling... his account had been initially to deny it,
yes,
and indeed to make several applications to the CCRC to set aside the conviction.
Yes.
Then, as release became more possible, the date approached, he asserted that he had repented, admitted what he'd done, or rather what he'd been convicted of, yes, said that was the limit of it, and gave a circumstantial account of how it had started at a time which you could put a date on.
Yes.
It wouldn't fit. Is this right?
It 12 but didn't fit 80, yes.
So there, the use that was being made of it was not, as it were, to tag him as we find you. Well, we don't know, because all the divisional court said was that the panel could use it for this purpose.
Yes.
But what they contemplated was that at least it could be used to test, yeah, the genuineness of his asserted self-reformation.
And part of the significance of that is that it was the additional matters, as in the 80 rather than the 12, could be used by the panel as part of their analysis without them having to find in each case whether or not what he said was true.
Quite.
Is it perhaps a matter of emphasis? Because if one places the emphasis on the allegation as opposed to the facts that have been found that relate to the allegation, then the emphasis is being placed on something which has not been established. But the facts themselves may be said to have been established, and they may have a bearing upon whether or not that particular individual is or is not a risk to the public were that person to be released. But the vice may be said to lie in the reliance being placed on the allegation as such, as opposed to the relevant facts that lie behind it, which have been established.
Yes, with the caveat that whether those relevant facts that lie behind the allegation may not be established to any particular standard. That's the particular issue which arises on the Court of Appeal's judgment. The underlying facts on the Court of Appeal's analysis must be ignored unless they're established on the balance of probabilities. That would have made the probing that the Divisional Court in Warboys envisaged difficult. What was envisaged in Warboys is in fact exactly what happened in this case in Pearce, because what was significant in this case, and I'll ask the Court to look at it in just a second, was that a number of allegations were made. One of them, as it happens, the panel found on the balance of probabilities was made out. But in relation to others, it was dissatisfied with the account given by Mr. Pearce when he was asked about them at the hearing. And that was a significant feature of the conclusions that the panel reached, and that's part of the reason why the Court of Appeal dismissed the appeal on the facts. It might be helpful to look at Mr. Justice Bourne's decision at first instance in this case, which is in the core volume at page 170. And again, really to focus on how the panel took its decision in this case, page 180, you can see at paragraph 46 a risk assessment report which listed 6 matters about which she had seen information from the police. And at 48, at the bottom of the page, an addendum report by the offender manager noting that at the top of 181, the claimant maintained his innocence in relation to the unconvicted matters. And there's then further detail. There are 8 matters listed there. I'm keeping one eye on the clock, so I may ask you to come back to those in due course. The decision is then set out on page 183. Panel discussed each of the allegations with you. You informed the panel you were arrested on many occasions when you were young. You said you tried to forget about the past. The panel didn't find it plausible that you would have no recollection of being arrested for multiple offences of rape and pressed you on the allegations. So the allegations are used exactly as envisaged in Warboys. The response was unconvincing, the panel found, and they took that into account in their assessment of risk.
Respectfully, is that not a fact?
Yes.
I mean,
Yes.
The matters which may properly be taken into account are indeed facts which are established, as one can see potentially there.
Well, there's actually quite a lot going on in that particular finding of the panel. There's an allegation which the panel may not need to make a finding as to whether it happened or not.
Indeed.
When they ask the prisoner about it, he gives an unsatisfactory response. Their finding about his response is a factual matter which they make a finding about.
Indeed.
Without necessarily needing to make a finding about what had originally happened, although they are entitled to conclude that that makes it more likely that it happened because he is evasive in the way that he deals with it. That I think I take from paragraph 99 of Shagang Shipping, the case, which talks about how there are facts which may make it more or less likely that other facts are true. We then have a straightforward contradiction. It's towards the bottom of that top paragraph on 183. You denied having sex with her in your evidence to the panel. At the material time, you did admit to having sex with her, but said it was consensual. So this is all a process of fact-finding. And that's why I say to you that in actual fact, the reality is that in almost all cases before the panel, there is something for them to work with. There are facts for them to find, which is why each of the examples, it turns out that there was a way that it could have been done differently. But that is not to say that a panel is, because it's possible to find some facts in many cases, it is necessary only to rely on found facts in every case. That's the difference which we say is an important one between the approach we asked this court to take and the approach that the Court of Appeal took. And at risk of going back to where I started this morning, the membership of the panel is particularly important in this because they are particularly skilled and experienced in working out what reliance, what weight can safely be placed on what may be difficult and complex matters. Just dealing with that question of weight, I'm coming to the end of at least towards the end of my submissions. Can I just come back to the guidance and what the guidance says about weight? Because there's one part of it in particular that the Court of Appeal was critical of, and that's paragraph 20.
Remind us of the page number.
I'm so sorry, page 434 in part 2 of the appendix. I gave the court the example of reports of a prisoner possibly having shouted slogans. One of the things that would be taken into account would be how reliable the report was. So we have, again, this is guidance rather than hard and fast rules. At paragraph 20, ways in which panels might want to think about assessing the weight of evidence. So the source, if the report of somebody shouting terrorist slogans is from a prison officer, it may carry more weight than if it's from another prisoner who is known to have a grudge against the person in issue. If it is supported by other information, for example, somebody else has recorded this, was it contemporaneous? What's the context? And so on and so forth. The part of this that the Court of Appeal was particularly critical of was C, nature of the allegation. Can I take you to the criticisms the Court of Appeal made of this? They start in the core bundle at page 160. At paragraph 37, the offending paragraphs are all concerned with the assessment of the relevance, weight and impact that an unproven allegation is to have on the parole review. And then just above G, paragraphs 20 to 23 then specifically require the panel to attribute weight to any such relevant unproven allegation and to determine the impact this level of concern has on the parole review, rather than basing the review only upon the facts that are established after the panel's analysis of the evidence information. Paragraph 20C highlights the mischief. When assessing the weight to give an allegation where it has not been possible to make findings of fact, it suggests that a serious allegation should bear considerable weight because it is capable of having a greater effect on the panel's risk assessment. With the greater respect, that's not what it says. It doesn't say that a serious allegation should bear considerable weight. It says simply that an allegation of more serious misconduct is capable of having a greater effect on the panel's risk assessment. That is not a proposition in my submission which is capable of serious criticism. Now, an allegation of a serious nature may end up having little or no weight at all if its source is unreliable and it's not contemporaneous, and the context shows for other reasons that it's unlikely to be true. But of course it's right that the more serious it is, the greater effect it's capable of having on risk assessment. What the Court of Appeal went on to say is that paragraph 46 on page 162, and this is a conclusion about a lengthy hypothetical scenario, which I'll come to very briefly before I sit down. It's a scenario which envisages allegations being made, and one of the allegations is in relation to a sexual assault. And the Court of Appeal felt at paragraph 46, this is by G, if there's some evidential basis for the allegation, the panel may proceed to make an assessment of the level of concern that the prisoner had been alleged to have committed a sexual assault, attaching great weight to the serious nature of the allegation in accordance with paragraph 20C. Well, it's not required to do that. It's required to form its own view, recognising that a more serious allegation may weigh more heavily, inevitably, in the process of risk assessment. And that approach in our submission suggests that the Court of Appeal really hadn't quite got to grips with the nuances of the risk assessment process that the expert panel members have to undertake. It's for the panel to decide what weight to attach to any matter. If the panel does attach weight to a matter, it will be subject to the supervisory jurisdiction of the court. If the approach taken to the attachment of weight is unreasonable in the Wednesbury sense, it will be challengeable. So, my lords, it may well be that your conclusion on the guidance as a whole really turns on the view you take of the central issue as to whether panels can only base their decisions on facts found to the civil standard. We invite you to conclude the approach of the Court of Appeal is wrong and that the guidance is lawful, and to allow the appeal. My lords, I don't know if there's anything else I can assist with. If not, those are my submissions.
Mr. Collins, thank you very much. Mr. Rule.
My Lord, may I return to where we began, which is the function of the Parole Board and its judicial role. And by reference, firstly, I appreciate, of course, that you've seen this only this morning, but section 28 itself, please, which we find at page 440, tab 1 of the authorities, volume 1. And I draw attention to it. The court, now having seen the decision in Re-H and other cases looking at section 31 of the Children Act 1989, there are some comparisons to be drawn with section 28 of the Crime Sentences Act 1997. On page 440, you'll see the duty to release certain life prisoners. And over the page, the particular test for the board, subsection 6, which shall not give a direction unless, when I go to B, the board is satisfied. And that's its approach. It is to be satisfied of the matter that that its function demands of it. And the question it asks is whether it is no longer necessary for the protection of the public that the prisoner should be confined. It's an agreed fact between the parties that doesn't import a burden despite the double negative, but nonetheless the important question, or the important point I draw attention to, if I may, is that it is necessary. It's either necessary or not, and the board is to be satisfied of that fact in its inquisitorial approach to discharging its statutory function.
It has to be satisfied that it is not necessary, not that it is necessary.
My Lord, I know there's the double negative. It almost could be read as importing a burden, but there is case law which has looked at that matter of the highest authority. So it's right to say that there's no burden in relation to the discharge of the question. But my Lord's entirely right. That's the statutory question that the board.
Well, test it this way, Mr. Rule. Supposing the panel says to itself, "I really don't know," then what's the default position?
Right.
My Lord, on the case law, there is no default position. The board will have to come to a conclusion. I appreciate my Lord is putting to me a scenario which could entirely exist as a matter of fact. I don't want to dodge a question and not assist the court, but it would be wrong of me to say, well, the default is to follow the statutory wording and to say that it is, therefore, you cannot release when the cases have not supported me in saying that.
Well, you say the cases don't support it. They do, actually, don't they? They certainly say that there's no burden on prisoners to establish anything in particular. But unless the board is satisfied that it's no longer necessary for him to be released, no longer necessary for him to be confined, then he stays confined, doesn't he?
Well, that I entirely accept is the natural reading of the section. For present purposes and for the submissions that I make, it's immaterial whether there is a 51 or 50 approach to answering that question, because they're not being, as it's agreed, a burden on a particular party.
Well, are you thinking of SIM?
My Lord, also in War Boys, there's reference to the fact there's no burden for the prisoner to show that he's no longer a danger. It's a theoretical possibility, which I don't think the cases have ever had to deal with. So if I can avoid at least adding one further matter to the court's agenda, I will certainly try and do so.
Well, I'm just conscious that in SIM, both Mr. Justice Elias, who knew a lot about this, and the Court of Appeal did, as it were, rephrase the test, but they did it, didn't they, in the context of a form of sentence which no longer exists, and the reasoning doesn't apply to the ones that do exist.
Absolutely right, my Lord, and they phrase it as a presumption. So the presumption in favour of releasing the prisoner during what would otherwise be an extended licence period, despite the fact he's been recalled and therefore comes for a probable decision.
Okay, well, as long as...
My Lord's absolutely right. It's not apposite, as it were, to the indeterminate sentence prisoner for whom there is no such presumption established in the case law. So far as the indeterminate sentence prisoner is concerned, one matter that I will draw the court's attention to momentarily is the Article 5(4) obligations which arise in the Parole Board's functions as a result of dealing with indeterminate sentences.
Yes, but Article 5(4) gives him the right to have the question decided by a court. The Parole Board is a court.
Yes.
For the purposes of the ECHR.
Yes, my Lord, it obviously therefore has to have the judicial guarantees of procedures, which is the point I'll make. It's not my Lord will notice from the authorities, I haven't weighed the court with European jurisprudence, but there is reference in our domestic decisions to considering the relevance of Article 5(4) in the processes and decision-making of the board.
Right.
So I'll make brief reference to it, if I may. But my Lord, I was dealing with Section 28, subsection 6, and the wording, and I've been rightly taken to task over it. But could I just draw attention before I leave it to the distinction, therefore, in being necessary, something that is necessary or not, or no longer necessary, rather than asking whether there is a risk that something is necessary, or positing a question such as reasonable grounds to suspect, or reasonable suspicion, or any of the other matters which could be part of the statutory framework had that been the language used. And again, we've seen the distinction drawn in Re-H into earlier parts of the process, and in this situation you have a relatively similar comparable if there is an arrest that happens on the basis of reasonable suspicion. The arrest itself may be the reason that there is then a trigger of a recall and the matter comes for a board. But that is a very different test being applied by an individual who arrests a police officer carrying out an arrest, as opposed to what the board must be satisfied about conducting a full hearing, as it were, to determine the statutory question. And my Lord, that being the statutory provision, the board's function has been considered in various of the cases in relation to its judicial status. And I don't immediately apologise, I may have to, for taking the court to certain of the dicta on this basis, that my learned friend addressing you from the Parole Board's argument seeks to liken the Parole Board's decision-making in this case to public law decision-making in a way that appeared to be distancing it from the judicial decision-making. And there may be little difference in terms of the way our public law principles are developed and the rigours in which we might have public law decision-making undertaken. But certainly it bears emphasis that what we are talking about in this case is the Parole Board making a decision as a court in the same way that civil courts make decisions and to an extent in the way that criminal courts make decisions when we talk about perhaps the dangerousness offending provisions, albeit of course the criminal standard applying to fact-finding in criminal courts more generally. So, my Lords, if I may take the court briefly to the emphasis placed on the judicial function in some of the case law, starting perhaps with the case of Brooke, which references Article 5.4, and that's our tab 21.
We don't have tabs.
No,
so
Lord,
if
yes,
you can give us the electronic page
It is
number.
page 1036 and following.
Thank you very much.
This is not the Brooks case with the S, which the court has already been taken to from 2004, which is important and which I will refer to in my submissions. But briefly, this is a case which came before the Court of Appeal in relation to the independence required of the Parole Board and its functions. I know that my Lord Hughes, who sat in the divisional court, whose judgment is upheld in the Court of Appeal in this case, will be familiar with the matter. But in short, the relevant passages are those which deal with the Board's role in our system, in our judicial system, requiring its independence and impartiality for Article 5.4 and for common law purposes. And brief references to that are given perhaps on page 104.3, paragraphs 20 and 21, where Lord Phillips, giving the court's judgment, Chief Justice, at paragraph 21, having referred to the independence and impartiality requirements, talks also of the Weeks judgment, which is concerned with Article 5.4, and which led to the Board having certain powers bestowed upon it. But in the middle there, next to letter G, guarantees appropriate to the kind of deprivation of liberty in question of a judicial procedure. So there is no distinction to be drawn between the panel's function under Section 28 and a court's functioning for the purposes of either our common law in my submission nor for Article 5 compliance with Article 5.4 processes where one is talking about an indeterminate sentence prisoner such as Mr. Pearce who would require those protections to be met by the domestic system.
So here's the critical passage, that which is cited in paragraph 21 from Weeks. Says what that's...
Yes, if you look to letter G,
yes,
you'll see there were various aspects to it. It had to be adversarial processes had to be incorporated so that there could be oral hearings, challenges to procedures.
yes.
And the particular
it's
phrase...
procedural matters, isn't it?
My Lord...
Independence, obviously.
Independence, impartiality,
And
the power
impartiality.
to decide.
Sorry?
My Lord.
And then procedural matters, is that right?
Yes. And it doesn't, for present purposes, go into a question as to whether or not a fact must be found in the judicial process or not. I accept entirely. But it's relevant, I think, to draw the comparison, as in fact Warboys does, and I'll draw some reliance on that, to that comparison with the judicial process in the way that we would generally understand it in a court system. So that is one reference to those matters of Article 5.4 and the court. This has been applied also, as you heard earlier, in the Gourlay decisions to the question of the court, the Parole Board rather, being treated as a court for the purposes of any cost proceedings, it's others. You have that decision in in the authorities bundle, and again it references the procedures in the same terminology. I'm afraid I can't draw any greater assistance from any of the cases than to give us this basic proposition that it is guarantees of judicial process that Article 5.4 would encourage.
Can you give us the relevant paragraphs in Goulet that you rely on?
So, my Lord.
It's at page 1086 it starts, I think.
My Lord, in Goulet, in the Court of Appeal, at paragraph 20 on page 1091,
Yeah.
and paragraph 22 on page 1092, the first reference has appropriate guaranteed judicial procedures, in inverted commas, so appropriate guaranteed judicial procedures, that's on 1091. And again, it's referring to the Weeks decision as the source. At 22, paragraph 22 on 1092, between letters C and G, and there's a reference there to Osborne, which I'll come to in a moment, but process is appropriate for a court. The Supreme Court decision is in the bundle following, but my Lord, it doesn't go into detail because it was a matter of cost practice for the Court of Appeal, and so while upholding the Court of Appeal and the practice of the board being treated as a court doesn't add anything further to this discussion. One then has the case of West, which proceeded to the House of Lords. It's, the Court of Appeal judgment is worth pausing on, please, and that you can find beginning at page 1526. And at 1538. This case concerned an argument that Article 6 guarantees applied to the process of parole, which was rejected. Ultimately, it's to be decided by the House of Lords on the basis that common law fairness, and as it was thought at the time, Article 5.4 in relation to determinate recalls, and that law has moved on in that regard. But on either basis, common law fairness, there was a requirement to hold oral hearings more regularly in the practice of the board. And the reason I refer to these cases is really the purpose behind why oral hearings are necessary before the Parole Board as part of its function, and why they're necessary to do fairness, and how that relates to the issues in this case. So, beginning with the Court of Appeal, and in the judgment of Lord Justice Simon Brown, as he was, paragraph 40 on page 1538, His Lordship, as the paragraph continues next to B, is explaining that in his judgment the Parole Board should be altogether readier than presently they are to hold oral hearings, if in truth their determination is likely to turn upon the resolution of important issues of fact. It's unnecessary to regard it in a particular case, but plainly it will sometimes be that the correct determination may, in some cases, only be possible following some form of oral hearing. So this is going back to 2003 and starting to look at the issue of oral hearings in the Parole Board. Lady Justice Hale also provides judgment, and if one looks at her judgment, she, in the minority, would have found Article 6 applied, but really because she was unhappy about that being the question and was concerned about how factual disputes should be dealt with. And if one goes to 53, we can see dicta there next to letter B. Such allegations may well give rise to the sort of factual disputes which arose in this case, and which in our traditions are considered best determined at an oral hearing. So factual disputes have long been part of why the Parole Board convenes oral hearings. In the House of Lords, if one goes forward to page 1562, please. This is in the judgment of Lord Hope, at the bottom of the page. because there had not been an oral hearing in those cases, his lordship says below H, but I agree that the absence of an oral hearing in these two determinate sentence cases was a breach of the duty to act fairly at common law. For reasons that I shall explain, I think that this means that the proceedings were not conducted in the way a court would be expected to conduct them, and it must follow there was a breach of the appellant's Article 5.4 rights. So his lordship directly relates there the 5.4 obligation to the oral hearing process and the role of the board to carry out a fair process in that way. Lord Slynn makes the same point at paragraph 60, just above on the same page. The case of Brooks 2004 is obviously an important one, but it may make more sense that I turn to that when dealing with how the Parole Board deals with allegations cases. Sticking with the subject of Parole Board or fairness and the court's discussion of that point, if I can invite the court's attention next to Lord Reid's dicta in the case of Osborne. That begins at 1266 of the bundle. In that case, there were three appellants. One was a determinate sentence prisoner, and one was two were indeterminate sentence prisoners. There were three appellants. And the case is famously cited on procedural fairness and the court's obligation to decide that for itself, or power to decide that for itself, but also in the parole context for the need for oral hearings as part of a process to do fairness. And again, we can see that expanding somewhat on where West had arrived, his lordship explains the nature of the process and what the judicial undertaking requires. Here we have page 1307, for example. Well, in fact, I should take my lords first perhaps to the summary, in case you're not immediately recollecting the case. It's set out as a summary form at page 1282, paragraph 2. And my lords, within that, if I could just draw attention to certain aspects of the conclusions that the court reached, Lord Reid giving the judgment with whom the remainder of the court agreed. At Roman numeral 2, you'll see on this page 1282 that one of the circumstances that would require the oral hearing was A, where facts which appear to the board to be important are in dispute. That's not by any means the end of the story, as Lord Reid was explaining in the course of the judgment, and it had been too often used as the only basis on which an oral hearing might be required, as if determinative facts were to be an issue or important facts were to be an issue. But it's nonetheless relevant that one of the purposes of fairness of the hearing is to resolve factual disputes. And if one turns over, my lords, you'll see there in the sub-paragraphs, you can turn to 6 and see some reference there to the way in which the balancing between the prisoner's interest in being at liberty and society's interest in detaining anyone who is dangerous, it is necessary to detain. We find there referenced with dicta, which his lordship is not the first to use. He's adopted that, but of course it comes from high authority in this source. When dealing with cases concerning post-tariff indeterminate sentence prisoners, it should scrutinise ever more anxiously whether the level of risk is unacceptable, the longer the time the prisoner is spent in prison following the expiry of his tariff. Now, again, there could be some difficulty in reconciling that principle with the fact that the test is one designed with public protection, as the Court of Appeal in this case was clearly cognizant of, and as the authorities have referred to on occasions. But there are perhaps, and I don't intend to invite the court to embark too heavily down this route, but there is perhaps some difference in the dicta you'll see in indeterminate sentence cases where this language has been used, and determinate sentence cases such as King and another case we have in the bundle where the test has been looked at, although it's in the same words, in the context of determinate sentence prisoners. But we've certainly seen the question of an anxious approach to the level of risk, and it may be explicable in our respectful submission by reference to the fact that the question of whether it's necessary or not has a degree of flexibility built in, the degree of hardship, the degree of time that has gone since there's been any offending. Those matters may well be relevant to the evaluation of necessity, but of course in the final balance, once you've decided it is necessary despite all of those factors, you would then be detaining because you've satisfied the test to do so. But that is, bearing in mind the discussion that my Lords had this morning with my learned friend, I thought it relevant to just point out that particular way of expressing the approach to the test and the question of the indeterminate sentence prisoner's loss of liberty on an ongoing basis. 7, Roman numeral 7, you have the board must be and appear to be independent and impartial as part of the court-like process, and not to be predisposed to favour official accounts of events or official assessments of risk. So part of the process that the board is undertaking is to avoid simply rubber stamping information it's receiving, views it's receiving, but undertaking its process to delve into that material and fairly establish what the basis is upon which it will make a decision. And by complying with these matters, it's also complying with Article 5.4 procedural fairness obligations over the page at Roman numeral 12. Those passages that I've referred the court to are elaborated upon in his lordship's judgment, but perhaps not necessary to give you more than a reference if you wish. 2.2, Roman numeral 2, is paragraph 85 on page 1304. Roman numeral 6 is at paragraph 83 on page 1304, and Roman numeral 7 is elaborated on paragraph 90 on page 1305. In the appeals themselves, the decision is that all three ought to have oral hearings, and in making that decision, the court was clear about the importance of important facts in dispute being allowed to be evaluated. And again, unless the court would wish me to take it in a slightly more leisurely fashion, I can give you the references for where the court deals with that principle in its application to the facts. Paragraph 98 in relation to Mr. Osborne, suggesting important facts were in dispute was the reason why he should have an opportunity, and the paragraphs within the judgment, sorry, that's on page 1306 to 1307. Paragraphs that relate those facts in more detail, I think I'll omit. You have the conclusion. And at 100, page 1307, you have in the case of Mr. Riley, significant disputes over the history of adjudications and failed drugs tests. So the dispute between the prisoner and the official accounts was whether he had been, whether there were certain facts about the adjudications that were relevant, his explanation for what had happened, and, for example, why he had possession of an item. He said he'd taken it from someone. These sorts of things that might be relevant to the risk assessment arising, and whether he'd failed drugs tests. So those disputes of fact were key to what fairness required by way of the board actually resolving those facts through an oral hearing mechanism. That then takes me, if I may, to the Warboys decision, factoring into this wider context of the court of the Parole Board conducting a court-like business, and in our respectful submission, Warboys further emphasises the comparison between the board and any court carrying out its functions, and it does so by reference in particular to the criminal court's sentencing provisions that deal with dangerous offenders, where risk is the issue for the court and the question of public safety is the purpose and the ambit of that process. So to firstly demonstrate that, may I ask the court to go to page 453, which is section 229 of the Criminal Justice Act 2003. You've been taken earlier to section 239, which is that directly concerned with the Parole Board, particularly emphasising one of the matters there was that the Parole Board was to rely on information, or was able to receive information, rather than something that would amount to evidence admissible in court. The same again is seen in the same statute in this provision, section 229, directed at the criminal court dealing with sentence, considering whether or not to impose, for example, the IPP sentence as it was, or extended sentences under the regime to which this applied. The comparable is really set out in paragraph 2, which is, and this, the form of this provision is as it was enacted. So it underwent some changes, particularly into subsection 3, which had an assumption of dangerousness for those with previous convictions. But if I focus on subsection 2, which remains more, remains essentially with minor alterations in force for the court's processes at present, one can see there that the court is taking into account information about the nature of the offence. So that's the index offence, no issue there. Taking into account a pattern of behaviour of which the offence forms part. Again, you're looking at the index offence, and it's C that expands that to all other information. So the court may take into account any information about the offender which is before it. So that's the direct comparison that we draw in the legislation between what the court is doing in a dangerousness case, an assessment at sentencing of dangerousness, and what the parole board is doing with its functioning, which you can see on the following page there with section 239. It was subsection 3b of 239. My Lords, while I'm at this part of the documentation, could I just invite your attention to page 456 to subsection 6 of section 239. This is concerned with the parole board, and I do so only because when I invite the court to look at the Reed D Northern Ireland case, there is a direct comparison with all of the legislation. One slightly different way in which it's put is this subsection 6, which invites the Secretary of State to give directions that must have regard to the need to protect the public from serious harm and the desirability of preventing the commission of further offences and of securing rehabilitation. So those are factors of public interest placed into the directions the Secretary of State must issue, or when issuing must have regard to in this subsection. The Northern Irish approach is slightly different, but still the wording will be redundant. So having gone to the statutory sections, now I invite the court to go back to the War Boys case. And in my submission, the appellant's submissions are in error with respect to suggest this is the starting point. War Boys is not a watershed of difference in the way in which the parole board has been carrying out its task. In fact, one goes back to cases like Sim, Brooks and others, which you have been taken to, which are as much a starting point, if not a greater starting point than War Boys. As important as the case undoubtedly was for reawakening the board's approach to unproven allegations. In this case, in particular, we are concerned to see, as I say, the comparison the court drew with this particular approach of the courts at sentencing, along with the approach of the board. If I invite the court to begin, please, on page 653, I think.
653,
please.
53.
My Lord, see here that the court was addressing submissions which it's relevant to note that were at an extreme end, as it were, on the board's behalf, that are not the first respondents case nor the Court of Appeal's decision below. The submission that the board had made at that time was that it was simply impermissible for the panel in War Boys to have even looked at the material that Mr. Justice Green was able to find on balanced probabilities, meant that Mr. War Boys was the offender in more than 80 further cases over a much longer time frame. So the board's submission, and I don't make that point as a forensic one to be awkward with my learned friend. But it is important to the context of what Warboys has to decide and what it does decide, that is essentially the proposition, that it cannot look at the material because the board hadn't obtained it, hadn't considered it. We're at the stage of what is received by the board, what is considered, not at a further stage of what you do with it thereafter, such as Brooks had to deal with, because it's the full situation, the full process. So at this, with that background to what is being argued about, at paragraph 146 was the board's submission that it was simply impermissible to consider whether there had been any further crimes committed by the offender Warboys. The court then considers the cases of Kidd and Farrar and Considine. You've been taken already today to Considine. You see those at paragraphs 147, 148 and 149. They are referred to by the court. I propose to take the court because it is helpful to Considine and Farrar because they also link to a case of Johnson which deals with fact-finding in this exercise. But first I draw the comparable between the board's exercise and the court's exercise. Having looked at those cases and having at paragraph 151 drawn the direct comparison between the information, as I was just inviting the court's attention to, as the material upon which either court received, either the board or the criminal court. The court then looks at 152 over onto page 655. And I should have said on page 654, they're regarded as broadly similar purposes in section 28 of the Crime Sentences Act, as are section 229 and dangerousness provisions. So Sir Brian Leveson was suggesting they're broadly similar purposes and drawing attention to the comparable wording of the statute. And at 152, confirmation of the admissibility of hearsay for the purposes subject to individual cases that might demand oral process for cross-examination. But the principle of admissibility of hearsay evidence is not in doubt, and he refers there, his lordship, to Sim, Brooks and McGettrick, as well as Watson's case. Then, having looked at McGettrick as you've been taken to, we go through to the court's conclusions, and applying that comparison between the statutory provisions, as you were taken to at 155, it may not be the role of the board to determine whether a prisoner has committed other offences. Our submission about that is an application of the West case, which confirms the board is not determining a criminal charge. So that's why you don't have criminal standard of proof, you don't have criminal admissibility of evidence rules, even though they're wider these days, but you don't have any of that there. So you're not determining whether there's a commission of an offence, i.e. guilt, for which there'd be sanctions, etc. But that doesn't mean, in my respectful submission, one reads this as in any way departing from Brooks, which has just been cited, as a way in which one deals with the evidence once you receive it, as a possible means of using the hearsay material, if it's fair to do so in that individual case. And so at 155, as you were taken to at the bottom, there's a suggestion, at the risk of repetition, the material could be used as a means of probing and testing the honesty and veracity of Mr. Radford's account. We submit that is plainly stated in the context that is exactly what had gone wrong in that case. That was what was being advanced by the claimant, not that there should, although the claimant did advance as well, that there could be findings of fact about those offences. Ms. Kaufman, Queen's Counsel's argument to that effect is recorded on page 619. So the claimant had not argued Brooks was wrong, or you cannot go on to use the facts to find anything from the hearsay. But the court is specifically minded with a complaint that they'd not been probing about this account. Everyone swallowed Mr. Warboy's account, as recent as it is. The psychologists have changed their minds. The board has accepted it without looking at the realities of the facts that were available, that had been looked at by Mr. Justice Green, as it then was, the findings that had been made, and the civil cases he'd settled at substantial cost to himself, and other factors that they could well have taken into regard and questioned him about. What they would have done thereafter would have been a matter to follow the Brooks approach, which is decide on the balance of probabilities what you find as facts from the material that you have received. But before you advance to that stage, you have to first receive the material, and that's what the board had irrationally not done, was to have received that material and consider it. And so it doesn't undermine or seek to undermine in any way the line of authorities that have preceded it, which were other uses or additional uses to which the hearsay could go. It merely confirms that you can fairly, in a given case on the consideration, use that hearsay in order to do something with it. You're not excluded from even considering that material, which was the argument that was being confronting the court. So on that basis, the court concludes it's driven to find that this was a case in which there should have been further inquiry. It sets out that conclusion at the bottom of the page from 152 onwards. Before I leave this case, you have reference also in the judgment to the approach to take, differentiating the two questions of considering a matter and making findings about it. The court at page 652, Divisional Court, in paragraph 143, is clear that you don't, in every case, need the allegation material at all. In many cases, what you're considering, particularly with matters that predate sentencing, is the risk factors that were identified and what is necessary. In order to satisfy the statutory test that the Parole Board is looking at, it is your current risk, not your past risk. So in many cases, if you have a sufficiently clear understanding of the risks, there won't be much need to go into the allegations at all. That will be a fact-specific consideration, of course, and it's simply worth noting that his lordship was, as is said in the criminal cases which we'll come to, saying that what you can work from are the facts you have in many cases without having to go into allegations at all. If you then go into allegations, if that's as a matter of the breadth of discretion for the board, it chooses to do that in a given case, then it's got to follow a certain usage for which one goes to the existing case law. And apologies for omitting it earlier, but at 152 there's also the point that's decided that there's no difference between a recall or a review case, which is consistent with certain other dicta, but I don't think that's a point that's been suggested. Now, the criminal cases which the court was referring to bear some cite by the court. And I know that you've been to Considine for some of the content there. Could I invite the court to go back to that case as my starting point? It begins at 1570.
So what is it you want to get from these cases, Mr. Rook?
My Lord, they help us. You've seen, obviously, that the connection between the statutory provisions and the information admission, but these cases go a little bit further about how you deal with an allegation in two ways. Firstly, in doing so, you try to find the facts. You're looking for facts on the balance of probabilities, or fairly, in the criminal context, just fairly established facts. And the second point that arises is that facts and allegations are separate entities, and part of the discussion that the court was having earlier, what is a mere allegation, what is an allegation, these are nebulous concepts, and it is the first respondent's case that they are not helpful. The reality is that there is either a fact or there is not a fact. Whatever the particular fact is will bear its own relevance depending on the entire circumstances and the other facts to which it relates. But the board's case is in essence stripped down. It appears to be this: if you have some facts, so there was an arrest, or if one's slightly more generous to the board's case, that there was information you were at a location that perhaps raises a question mark. The board's case is that is sufficient to say you can have a concern about an allegation that what he did at that location was X. You can take into account that full allegation because there's some evidential basis for it. The reality is quite separate, we submit. You take into account the facts that you establish. If the fact is established that he was at a location, you may be concerned about that. That in itself may be sufficient to find the relevant risk that the individual is now exposing others to or himself to, such that you justify the statutory test's imposition. But it doesn't mean you leap from the one fact you know to the unknown and treat something which has not passed even a balance of probability threshold, the lower of the tests available, the two that are recognised in the law, and we submit there are only two. There's no scope for real possibility or significant chance of. It's a fact or it's not. It's binary 1 or 0 attributed, as my learned friend was addressing you on earlier, if you pass the balance probability threshold or you do not. So these cases are essentially concerned with how the courts operate the situation of dangerousness assessment, where they're faced with an allegation and it has constituent elements or associated other facts. Lady Justice McCurr referred to constituent or consequential facts. I used the term collateral, which is perhaps one best avoided because it could be taken as a term of art. But by that I mean essentially other facts that may be smaller facts. And if one turns to some language that we'll see from the Re-H case and others, micro or macro facts could be the terminology. The micro fact being he was at a location, other things that might put together involve him having committed an offence, which might be the allegation. The macro fact, if one uses that terminology. I haven't perhaps decided on what's the best terminology. I'm happy to be led, but the position is that it means the same thing. You have an allegation as a whole, which may be a fact that is found. For example, there was an assault, or you have an allegation that is not. For example, he was there was an argument, but we have not decided it's probable or not that there was a strike or that there was an assault. So we have concerning behaviour in being there, in being in drink, in being in an argument. We might regard those as relevant facts for our risk assessment, but they are the micro facts on an allegation of assault. But whether they're termed as such or constituent elements, constituent facts, the position is you can take into account those facts and bear them in the risk assessment. What you cannot do is jump from there to say, well, actually, we'll treat the assault as if we found it to have happened, when we simply just haven't. And that's the board's case. That's the allegation to which you're allowed to give weight because you have an evidential basis, even if you haven't found it to be probable.
I don't think that Mr. Collins is actually saying that if you can't decide whether it happened or not, you behave as if you have decided that it happened. I think what he's saying is that you don't exclude it because you can't find it as a fact.
My Lord, I take that nuance, my Lord. I find it difficult, respectfully, for this reason, that if one is dealing with an actual decision-making and you actually have before you an individual, you have to decide whether or not the risk is there or not, how does one treat a non-fact which you are giving weight to, other than by treating it as if it had occurred, unless you're to attribute a percentage weight to it in some way that would cause some gymnastics in the mental process, no doubt, saying, well, I'll discount, because I'm not sure, because I haven't found it probable that happened, I'll discount to the level of possibility I think it is and add that into my level of risk assessment. We submit it's an impossible task for the board that is being set up, and it's not one that it needs, nor one that assists in it doing its work in a fair manner at all.
At the very least, may it not be taken into account as part of the risk, because one has to assess the risk itself. So one's going through a process of deduction and inference in answering the statutory question.
Oh, my deduction and inference is not disputed. So there's no difficulty with the inferences you take from the known facts. But that's a perfectly permissible reasoning that the courts undertake all the time. And nor is there a problem with a prediction of future harm, even if it hasn't yet happened. So the factors around it suggest it could happen rather than it has happened. But what you are doing in both of those instances is a perfectly permissible judicial exercise of taking a known fact and drawing from that either an inference of another fact. So the circumstantial facts will add up so that you can draw the inference, well, this did happen, or it's probably happened as a result of those other facts that you know. Or you're drawing a risk evaluation from those known facts to say, well, this is very concerning in terms of the necessity of confining you, more than minimal risk. We've a low threshold to meet, but we've decided that, yes, those factors, being present, being drunk, all of those factors add up to that risk. You don't need the extra step of a criminal offence or something else. If you can find that, if you do, of course, that's relevant. But if you don't find it, we simply submit that you can't convert that into some weight or some relevance when it simply doesn't bear a factual finding. It hasn't been established to actually be a probable matter. So, my Lords, with that discussion, I've got, I think, some further time this afternoon. If I could invite the Court to go to those criminal cases, just for the brief points that I suggest they might be assistance with. Considine, firstly, you've been taken to some of the matters here. This was a case in which there'd been bad character at the trial. You can see that on page 1573. Essentially, there had been an account from the complainant at the trial, before the judge, in court, of bad character, history of violence towards her during the relationship on the part of the defendant, who was facing threats to kill, as the allegation, which might suggest why all of the matters were put in that way, because, of course, mental state becomes relevant in such an offence. So the court in that case had received the evidence from the individual. The judge was in a perfectly satisfactory position to make findings of fact about it, which he does, taking account of the evidence from the complainant of those further violent incidents. The court looks at various of the authorities, but in particular, if I draw attention to the fact that Johnson is referred to at 28, I don't think the court was taken to earlier, but Johnson being referred to as the leading guidance case on section 229 at the time.
Which page is that on?
Sorry, my 1576, my Lord, paragraph 28. Then there's the discussion of Farrar, which you were taken to earlier. And if I go through to page 1578, the court, having agreed that a Newton hearing to avoid the proper process of trial, etc., wasn't appropriate. At 35, the court said this: these considerations are consistent with the comment in Johnson that when reaching a conclusion adverse to the defendant, the judge should not rely on disputed fact unless it could be resolved fairly to him. There's no suggestion that the criminal courts should be dispensing with facts as the basis upon which they pass a sentence, despite the fact they receive information, despite the fact they're assessing a future risk. The suggestion finds no entertainment in the cases, nor any support. And so when my learned friend took you to paragraph 37 on page 1579, the context in which the court is not laying down hard and fast rules about how to approach the resolution of disputed facts in a section 229 assessment is concerned with how in that case you would achieve fairness. It's not to be read as saying we are in any way endorsing that you wouldn't find a fact that you then propose to rely upon. Well, it encourages reliance.
Is that what Lord Judge is saying in 35? I absolutely understand what you can read into the first sentence. Should not rely on a disputed fact unless it can be resolved fairly to it. But that begs the question of when it can be. And one example of unfairness which is given would arise if, notwithstanding the availability of evidence to justify prosecution for the offence, he was undercharged and the prosecution ended up with supplying the court with the material as information, which to all intents and purposes meant that he'd been treated as if he'd been convicted when he hadn't been. Understood. But what the next paragraph says is that Farrer clearly did not decide that absent a conviction, the court making the 229 decision is precluded from considering evidence of previous misconduct. The contrary is true.
Yes.
They don't actually doesn't go into the question of how you resolve any dispute of facts, does it?
No, my lord, but my understanding was that paragraph 37 had been cited in isolation on the understanding that what it meant was no hard and fast rules. You might not need to actually find a fact at all. Not rather than process, rather than we're not saying that you have to have it admitted under formal bad character, section 101, the types of things that came up in the cases, including Considine, as to how you receive the evidence. But the evidence having been received in a fair way, my proposition, our proposition, is that you decide that evidence, you decide from that evidence what information, what facts you find.
Yes,
and that's what happens. That's what Farrer did. If one just looks at B on that page, my lord, 1579, letter B, in Farrer, the end result, as I'll seek to demonstrate in a moment, was material directly related to the earlier incident, did contribute to the conclusion he should be assessed as dangerous. Yep. And again, we're talking about the micro facts, the constituent facts, when we turn to that case. But putting 37 in context in this judgment, my lords can also see the conclusions reached in that case on the two appeals. If one goes over to 1580, within paragraph 39, there's citation of the reasons given by the single judge for refusing leave, which are adopted. If I invite the court's attention to letter D, further, I consider that the trial judge, who had heard the evidence of the complainant and the applicant, was entitled to make a factual assessment that there had been serious violence inflicted by the applicant and the complainant over the years.
Because in that case, the evidence, it was bad character evidence, it had been given in the trial.
Exactly. So it's been fairly admitted. There was a process in which it was tested. The judge was able to assess the witnesses, the complainant's evidence, the defendant's evidence, etc. And he was quite right. But what I'm drawing attention to there, my lord, is that there was a factual assessment.
Oh, yes, there was in that case, yes.
So the court is endorsing using the material, the information, to make these facts and then draw from those facts the assessment of dangerousness, because they're facts. Okay. And it does it in both cases. You can see at the bottom in the Davis case again, right at the bottom below H, no question but that on the facts the judge sets out, he's entitled to come to the conclusion. So it's about the facts. Neither judge had said, I'm not able to say whether that's probable or whether I'm sure about that matter, but I'm relying on it in order to form my conclusion on dangerousness.
So you see that at paragraph 41H, do we, on 1580?
Yes, my lord, at the bottom of that page.
On the facts set out. Is that your point there?
Yes. And then if you go over the page, it ends with "and applied his mind to the relevant facts." But the central proposition is that there is nowhere a reference to the idea that you would decide these matters without reference to facts. How you do it, the procedure you follow, what fairness demands in a particular situation, those are all matters left to cases to decide. But what is not in doubt is that you are fact-finding. And Johnson was the case there that you just saw being mentioned in relation to dealing with the guidance on finding facts. If I can invite the court's attention to that case, again, it was a number of appeals brought together in a court to give guidance. You find that on 1593. At paragraph 3, letter D, on 1593, the court will see that the court was clear about what this sentencing process is about. It's about the future risk and public protection. The assessment of risk must be based on the information available.
So where are you?
Sorry, my lord. Letter D on page 1593. Sentences concerned with future risk and public protection.
Yes.
And if one goes to the paragraphs that were cited in the other cases, over to page 15, there's a very long paragraph 10. If one goes, I should in fact start at the bottom of 1595. Roman numeral 5, which begins next to letter
What does
G.
information mean there?
So that's using the terminology of the statute. That
Yes,
any information.
I
So
see, simply-
if there's a
simply
police
repeating
report, so rather than it being a formal Section 9, Criminal Justice Act 1967 witness statement, you just receive a report. Here's a police report, something of that nature, and you can take it into
But
account.
you say that has to be, the information has to be more probable than not.
Absolutely. You take all of that material, you consider it all, but the process is funneling towards what you find are the facts, having regard to all the evidence, and each bit of it doesn't need to necessarily have its own probability. It's about what you make of it all, which is why you have an inference of a fact from the surrounding circumstances in certain cases. But what we don't have is something which isn't capable of being assessed to be probable, taken forward as if it's relevant or carries weight.
So you look at the information.
Yes.
You say, well, that isn't probable, so I disregard it now.
Yes. If you're unable, well, if whatever that particular fact is you're talking about.
Yes.
So if it's the only relevant fact and you haven't found it, disregard it all. But if there was some relevant parts, all relevant facts would be considered. But simply anything you could not say,
It's probable.
I find this has probably happened, you would then go to the disregarding stage. Because it couldn't bear logical weight and relevance in your ultimate decision in the next stage. So at the bottom here on 1595, the court was dealing with the usual practice of receiving information from the prosecution in good time, etc., about offences and about information, but in short, failure to comply with that wouldn't itself prevent you from looking at it and, for example, asking the defendant what his account was. So if you didn't have the information from which you could draw your own conclusions, then you would be working on the basis of the facts that you might obtain from a defendant in any event through his counsel.
Sorry, was this a reference, did you say, to page
1595?
I'm sorry, you're losing me at this stage, I'm afraid. Where's your argument going?
My Lord, just in terms of what you're basing your decision on, if the prosecution couldn't provide you with the information, you could base yourself on what the defendant said, but that's a way of having a factual basis to your decision making that isn't a disputed one. You then don't obviously have to take that forward into a fact-finding exercise. You have an agreed fact, a fact from the defendant.
But you may have evidence or information that comes in different forms. You assess it all.
Yes.
And you make findings of fact.
From all of that material, yes.
That's your submission, as I understand it.
If it's not in dispute, of course, you're welcome to rely on it, but if you're satisfied of it yourself. But on the question of adversely holding a fact against an individual, that's on 1596. It's the end of the paragraph as it goes over the page. And it's followed immediately thereafter by, at the risk of stating the obvious, the final consideration we draw attention to this court. I appreciate talking about the Court of Appeal Criminal Division's appellate responsibilities will not normally interfere with the conclusions reached by a sentencer who has accurately identified the relevant principles and applied his mind to the relevant facts. And that may sound very trite, but of course the proposition being advanced is that that should not be the only occasion on which the court has to review a decision. If the Parole Board's argument is right, then a court should be reviewing a decision taken as to someone's risk or not only on the basis of the mind being drawn to relevant facts, but on what rational weight was given to a non-fact, to a matter that was not established, in terms of coming to the conclusion.
That particular finding at the top of page 590 of the report, on page 1596 of the bundle, is the one that you focus on, at line A.
Yes, next to letter A, at the end of paragraph 10.
Yeah.
But I submit also that paragraph 11 is illuminating in the sense of considering how these go together, how these two work together. My Lord, I'm conscious of the time. I had intended very brief submissions about Farrar, which is the last of those criminal trilogy, which we have in the bundle as well. I'm happy, obviously, to not trespass onto the next few minutes, if you prefer me to.
Well, if you think you are proceeding at a reasonable pace, we can, and we'll finish in time tomorrow. We can rise now. Thank you very much. adjourned.